Session to order. This is Tuesday, June 4th of 2013, and I'd like everyone to rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to welcome everyone. The first item on our agenda are 3 public hearings, 2 of which are rezoning applications. Let me, before we begin, explain the procedure so everyone is on the same page. We will call the applicant forward and swear them in. They will present their case. We will hear from the staff, and then we will allow the public to comment for or against the application. And we will also ask you to be sworn in before you testify. So everyone that has a concern will be given the opportunity to speak regarding the rezonings and the one legislative bill that we have regarding the amendments to a zoning ordinance on floodplain regulations. So the first rezoning application is file number 2013-01 regarding property at 2758 Augustine Herman Highway. So I'm going to ask the council manager to read into the record this application, and he will then request the applicant come forward to be sworn in.
Public notice was given on Wednesday, May 1st and May 8th, 2013. A public hearing to be held at County Council on Tuesday, June 4th, 2013 at 7 at the County Administrative Building. This case, file number 2013-01, applicant is Capital Development Partners, LLC, care of Frank Madison. Property is located at 2758 Augustine Herman Highway in Chesapeake City. Request is to rezone 0.6479 acres from Southern Agricultural Residential, SAR, to Business General, BG. Property owner is John W. and Helen A. Myers Sr. Would the applicant and council come forward to be sworn in?
Can everyone hear the council manager? Yes? Okay, great.
Do you solemnly declare and affirm under penalties of perjury that the evidence you are about to give in this matter not pending shall be the truth, the whole truth, and nothing but the truth?
My name is Rick Leopold from Milestone Commercial Realty, representing Capital Development Partners. And just clerical error on the application, the name of the gentleman who filed it, his last name is Cason, C-A-S-O-N, not L-A-S-O-N. We're here to request a rezoning of the back portion of the Jack and Helen's restaurant property. It is our contention that the property was zoned, not rezoned during the last comprehensive rezoning in 2011, and perhaps 2 or 3 before that. This property has been for the last 30 years owned and operated as Jack and Helen's restaurant property, and has been used as such. It has never been used agriculturally in the last 30 years that we know of. It's always been their business, and therefore we simply state the case that it has been missed in the comprehensive rezoning that should have been BGL this time.
Is that the end of your testimony?
That's all I'm here to say.
Okay. Does the staff, do any of the council members have questions of the applicant?
I apologize. The question that was presented earlier, we do want to see if we could get a change in the application to amend it slightly. We had a very small .08 strip of land at the back of this parcel under contract that is also zoned SAR. And in this rezoning, if this parcel 390 is rezoned business general, and if this parcel settles in this tiny little strip in the back is also rezoned, we would like to include that as part of the business general zone. It's currently under contract, but we won't know until probably November or December if the property is actually going to sell.
Was that originally on the application?
It was not originally on the application, it was brought up at the planning and zoning meeting.
It was brought up at planning and zoning?
Yes.
Ms. Campbell, could you weigh in on this?
It's my understanding that at the planning commission meeting, the application was amended at that time to include that sliver of land. The theory being that anyone who would have been interested in the rezoning would have attended that meeting based upon the advertisement of the rezoning paper. And that with it being amended at that meeting, it was allowed to proceed with the sliver of land, the .08 attached to it. So it's our position that it already is a part of the application, not that we need to amend it at this time. It was amended before the planning commission meeting. Thank you.
I have a question. Mr. Leopold, this parcel of land, I assume it's adjacent to the restaurant parcel. Has it been used an accessory to the restaurant?
No, it is not. It has been completely unused by either the current owner or Jack and Sons.
So it's next to and adjoining but not been used?
I have flyers if you'd like to see a diagram of what it looks like.
Sure.
Mr. Leopold, may I have a copy as well, please? You have a spare?
Yep. From parcel 290.
Yes.
So you can see this strip of land is less than 6 feet on the northern side, less than 17 feet on the southern side, and about.
So with the addition of that parcel, that would open up the argument for a significant change of character. If someone were to come in for under a rezoning in the area, I can understand that there was a mistake, your argument that there was a mistake in the comprehensive rezoning because it was being used as BG. But this parcel was never used by Helen's Restaurant. It was?
390 has been used. I thought you were talking about the strip of land. My apologies. The 390 has been and always is. It is where this current septic system drain fields are located. There's a storage building in the back. They use to store equipment and materials.
That was my question. Was 390 used as an accessory use
Yes.
to the restaurant?
Yes, my apologies.
And what were those uses?
The septic system is there, as well as a storage building for equipment and materials.
Does the parking lot behind the restaurant kind of form the property line between 382 and that 390?
Yes.
Are there any other questions from the council members?
Director Sennstrom, can you look at the parcel? The blue area, that's a part of the stormwater management?
The blue area that is highlighted on here is the .08 acre piece that he referred to as the amendment to the original 6.74 acres that they desired to rezone. What is situated on there, I do not know. I don't know if there are any improvements on there. You'd have to ask the applicant. I don't know if they have anything located on that piece or not.
Well, he's saying that the stormwater management was part of that parcel.
The septic system.
Oh, septic.
Are there any other questions from the council members regarding this application? We're going to open it up to the public comment for this application. We would ask those that are for or against, to everyone please stand so that we can swear you all in at one time. So everyone that would speak for or against this application, please rise.
Would you raise your right hand and swear? Do you solemnly declare and affirm under the penalties of perjury that the evidence you are about to give in this matter now pending shall be the truth, the whole truth, and nothing but the truth? I do.
Okay, as I call you up, and we will ask you to speak in favor of the application or against the application. We will not be answering questions, but you can speak to matters regarding the application. Please address your comments directly to the council members. Do not address the applicant nor other people that may speak in favor or against this matter. We want to hear what you have to say. Please keep it respectful and civil. So, Mr. Jones, did you want to get first in line?
I do. I represent the parties in opposition. I have some things I'd like to introduce, and also I'd like to introduce some witnesses on behalf of the
Okay,
opposition.
then would you start by introducing your name and
Yes, sir.
where you're from?
My name is Robert Jones. I'm an attorney practicing law in Cecil County. My office is at 157 East Main Street in Elkton, Mr. President.
Thank you. Go ahead and proceed.
I have here a packet that I would like to introduce in evidence, and I have copies for each of the board members. The packet includes this in evidence and also petitions signed by about 349 people. I would like to go through the packet that I have introduced to you. There are certain pages from the 2020-10 Comprehensive Plan. You'll note that 3.52, rural areas. The county intends for rural areas to remain rural and in agriculture or other natural resources within them so that they can remain viable. The county will continue to support permanent preservation of these areas. Paragraph 3.7, policies and actions. It refers to the fact that between 1997 and 2008, 50% of the county's building permits were issued for development in growth areas and 50% outside the growth areas. The comprehensive plan recognizes that 50% of building permits outside the growth area exceeds the desirable share. 5.51, scenic roads. You, of course, have adopted the State Highway Maryland Scenic Byways program, and there are 3 scenic highways in Cecil County. One of them is, of course, Maryland 213 from Kent County to Chesapeake City. That's an entire highway, is a scenic highway under that state program. In 7.3, future growth and development. The potential encroachment of future development on sensitive environmental, agricultural, and forested resources is an important issue facing Cecil County. Development where these resources are increases fragmentation. The county has taken steps to reduce development in these rural areas. Also, you'll note on 7.3.2, you've established priority preservation areas, which I submit this area is. The comprehensive plan use map that you see indicates that the entire area south of the canal, this is a line in the sand that over the last 40 years, this county government has drawn, and it has identified a special resource preservation district because of the agricultural, the historical, the scenic waterfront areas that is in this area. That line in the sand has been held by this county government. The SAR zoning is a special zoning just for this particular area in the county. As I point out, it encourages the retention and maintenance of the agricultural land and wants to prevent premature urbanization. The zoning map indicates those areas in this particular neighborhood, which are currently zoned PG, and of course, this particular property is not zoned PG. I will have Mr. Pugh testify briefly in a minute, but I want to draw your attention to the company that is the applicant. It's a South Carolina company, it's not a local company. This neighborhood in this area has traditionally been family-owned businesses, which is what Jack and Helen's was. The application indicates that the proposed use of this property, general commercial. There is no contract submitted for any particular commercial use. As you'll see between the two deeds that follow up, this would be an area of over 2 acres. That's enough to put a McDonald's in, and if you rezoned this, you could put a McDonald's on that property, ladies and gentlemen. There is an actual plan which shows the overlay of a new Dollar General store. And when you go through the next exhibits, which are the original deed, Mr. Jack and Ms. Helen, when they bought the property, you will see that there is actually an original deed when they acquired the 1.5 acres. And then they acquired that from Calatex of Delaware. It was commercial land because Calatex owned the gas station, which is there today. A year later, they had to go to Cherry Humper, who owned the farm behind, and they had to get the additional 0.6 acres. And you will see the actual subdivision plan, which I have attached in this now in evidence, and you will realize that that plan has certain restrictive conditions and covenants which were placed upon it. Lastly, in the package, the state planning office has priority areas identified for future planning and for future use of the water and sewer, which is going to be installed down at Bohemian Manor High School. The map indicates that this particular lot is not in the priority planning area and therefore does not qualify for any water and sewer, which may be available after the capacity of Jack and Helen's is determined. I would call Mr. Mike Pugh up as my witness. Mike? State your full name and address, please.
Michael Pugh, 11 Ground Pine Path, Elton.
And have you been qualified as an expert witness in planning and zoning before various boards and courts of this county and this state?
I have.
And I would offer him as an expert witness in that field, Mr. President.
Okay.
Have you, first of all, Mike, have you reviewed the application itself?
I have.
And what do you note about the application and any of the plats that are attached to it?
Well, the first thing that I note has been alluded to earlier, drawing your attention back to the discrepancy between the application in terms of the amount of land involved versus the actual deed itself. When the property was created, it was based on this approved subdivision that you have in your packet. It's 0.648 acres. The plat that was submitted by the applicant indicates a parcel which has been noted, which is larger in content than is what is stated in the application. I think that what that puts you in a position of being asked to do is to rezone a portion of property that's not in the ownership of the current applicant. And in looking at the application in the files, I find no indication of a signature on the application or any application of this additional piece of land consenting to this rezoning. One of the principles of the rezoning application process is that the property owners involved in a request must sign their acknowledgement and agreement with the application itself. So in my mind, there is at least a defect in the application in that it was not advertised, nor does it contain, or it also contains more land than is part of the property.
What is the significance of the advertisement and its defect?
Well, the advertisement is to give general notice to the public and the surrounding property owners of the nature of the rezoning and what is being applied for. And essentially, it is to give people the opportunity to review it and to see if they have any issues or comments they want to bring forward. The application in this case does not include all of the property owners, as I say, so therefore I think that it lacks clarity as to what is being applied for. Now, I do understand that it must have been modified at the Planning Commission. I wasn't there, so I have no comment on that process. I would simply note that the advertisement is the only mechanism by which people have to familiarize themselves with an application, and absent any further public notice, no one could reasonably know that there is an additional parcel that's involved in this application, which is evidently under contract for transfer.
Well, we have no knowledge even who the property owner is at this point.
I don't.
Right, I don't think that's in the record. I would also draw your attention to the 1979 plat. Was there restrictions on that subdivision approval?
Well, there was. When the subdivision was approved, the context of this subdivision in time was that there were problems with the septic system on this parcel, on the Jack and Helen parcel, and there was an opportunity to create a repair that the health department, working with the applicant, discovered some land that would assume the ability to handle the effluent from the operation, and so an approval was made for the addition of lands. But as you can see from the note on the subdivision plat, the approval of the indicated transfer is solely for adding to adjoining development, or adjoining holdings, excuse me, and not for development. So at the time, the addition of lands was only created in concert with the repair of the septic system. Moving forward to the issue of the condition of the zoning at that time, the property at the time that this was approved was zoned residential, R2. In two subsequent comprehensive rezonings, this parcel, not including this additional amount of land, remained in a non-commercial zone condition. In fact, it was zoned agricultural residential. So therefore, there is, in the history of this parcel, no indication that there was ever an intent to, as the note on the plat says, use it for further development. So therefore, my position is that there is not a mistake in the existing zoning. The zoning lines are clear, the history is clear. The use of the septic was incidental to the actual commercial use and not part of the overall commercial operation.
Is it your understanding that our research of the Permits and Inspections Office indicates that there have never been any building permits issued on this parcel?
That's my understanding.
Now, with reference to the mistake argument, would you please go through the various factors that the board must consider, Mike?
Well, first of all, there are two issues. One is whether or not there was a change in the neighborhood, and I think that it's pretty clear that in a year and a half since the comprehensive rezoning, there have been no changes. So, disposing of that, it leaves us only with the mistake argument, and I've just outlined for you the reasoning behind the fact that the parcel's creation was not for commercial purposes. So therefore, in my mind, no mistake was made. It was a deliberate act to incorporate the repair of the sanitary situation. So therefore, no mistake made.
Is that your opinion as an expert in the field of planning and zoning?
It is.
Okay. What is the significance of, as has been indicated, as I've indicated, and is obvious, there is water and sewer lines coming out of Chesapeake City down to a problem which Bohemian Manor High School is having.
Correct.
And the town of Chesapeake City, in conjunction with county government, is basically implementing that line.
That's correct.
What is the significance of the ability for any excess usage to be available to different property owners in the Chesapeake City area who might be served by that excess capacity?
The background for this is, in terms of its importance, is that the comprehensive plan of Cecil County basically says that the extension of commercial zoning and development in the area outside of Chesapeake City should be made a part of the decision-making process of the town of Chesapeake City. That the county relies on the town's decisions regarding its infrastructure extension as a primary indicator of where development should occur. Now, In doing that, as this extension is occurring to Bohemian Manor High School, there will be some additional connections that will be made available, and the town has set up a formula by which these connections can be accessed. However, in this case, this property, this particular portion of the property is not located in the priority funding area. Therefore, the town would not be able to extend the utilities into a parcel without having its situation revised to reflect being a part of the priority funding area. Now, the reason that that's important is if you go back to the site plan, you can see that the construction is not only the parking lot, but the building itself overlaps the line. And the building, as well as the parking area, becomes a part of a construction in an area that is designated as a non-priority funding area. So therefore, in terms of the comprehensive plan, it fails to meet the test of consistent as far as the town of Chesapeake City's extension of services is concerned.
And the priority funding areas are established by the state planning office, is that correct?
That's correct, in consultation with the local jurisdictions.
And that is the map that we've submitted into evidence, which clearly reflects from the state planning office that this has not been designated as a priority funding parcel.
That's correct.
That would be my questions. Oh, go ahead, I'm sorry, Mike, yes.
A couple more quick points. First point would be that if you look at the zoning map of South Chesapeake City along 213, you will notice that it's a very finite amount of commercial. It's not designed for a large amount of extension and expansion. That's on purpose. The desire is to not have a situation where a lot of strip center commercial is created along 213 in the area below Chesapeake City, because in fact it's also part of the state's scenic byway program. And so therefore maintaining a limited amount of commercial is also a desire on the part of the comprehensive plan. I think that is.
Okay, thank you. Are there any questions of the members of the board?
Not that it should matter to the board regarding the deed restriction, but where is that in the documents that you provided to the council?
Mr. President, if you look under where it says subdivision approval, there is the date, and then there is a
Are you looking
type.
at the plat?
The plat.
Yes, sir, it's on the plat. It's actually a restriction on the plat. A restriction placed on.
It says any future subdivision of this land or building development will be submitted in greater I don't see it saying that they're prohibited.
We didn't suggest that it is prohibited, but we're saying that at this point, it has never been submitted for the appropriate creation of a development parcel, which would include the attachment of the land to the parent parcel.
That would happen after the rezoning. They would have to come before the planning and zoning and planning commission to get that approval. It doesn't expressly prohibit it.
It doesn't expressly prohibit it, but it indicates that there's a process that has to be followed. If you're suggesting that the process could be as a result of the post-rezoning activity,
Right.
I'm suggesting to you, because the parcel is not as a part of the priority funding area, and it's inconsistent with the comprehensive plan, it's not appropriate to start down that path, and that process should not be rewarded with approvals.
Okay.
I had asked the question earlier this morning, if the parcel was being used, even not stormwater management, but for septic for Jack and Helen's restaurant, it was being questioned, challenged by the public, that they could be challenged to have to go through a rezoning to make it consistent with the zoning on Jack and Helen's. Well, that would be BG. Is that correct, Director Sundstrom?
I'm not sure if I understand the question. You're saying if it's approved,
No,
and
you were saying this morning that if it was being used for the operation of Jack and Helen's restaurant, it could be, they could have been made to have sought a rezoning for it to be a commercial property.
I think what you're referring to was the discussion this morning concerning the last comprehensive rezoning and whether or not an application was put in.
No.
No?
I specifically asked you this morning
Mhm.
if that property was being used for stormwater or for any other use for the operation of Jack and Helen's Restaurant, if that would have to, if they would be obligated to get that parcel rezoned as well. And you said yes,
Only if there was.
if it was challenged.
Oh, yeah, if somebody complained and said that they're using residential property for commercial use, then at that point, we would investigate that complaint and verify that there is veracity to that. If there is, then we would notify the individual either to cease using it as an accessory to a commercial business, or advise them that their other option would be to seek a rezoning to change it to commercial.
And what does concern me though is the ownership of that parcel. And I think they're right, that the owner of the parcel needs to be on the application, correct?
You're referring to the sliver, I would assume?
Yes.
Not parcel 390.
Any part of that land that's being, requested to be rezoned.
Yeah, the property owners need to sign the application for rezoning.
Do you have any other testimony, Mr. Jones?
Yes, Mr. President. State your full name and your address.
Danny Patel. I live in Middletown, Delaware.
You own and operate the gas station, the Valero station next to Jack and Helen's.
Yes, I was, since 2006.
And during that period of time, have you watched the activities over at Jack and Helen's?
Yes, I have.
And where are the deliveries, for instance, the Cisco truck, the Coke truck, where are all deliveries made to Jack and Helen's?
Back of the restaurant.
Back of the restaurant door. Are any deliveries ever made to that building out in the back?
Nothing of mine.
And what basically have you seen done with that building in the back?
Look like a storage room there.
For their lawnmower?
Lawnmower and stuff in there.
Okay. And you're in opposition to this, are you not?
Yes, I am.
Okay. Thank you very much. State your full name and address and what would you like to say?
I'm Lee Howard Glosters, and I live in Chesapeake City, Maryland, on Randalia Road. I was born and raised in southern Cecil County. I am a landowner there. I've seen many changes here over the years, some for the better, others for the worse. I have never seen development, commercial or otherwise, revert to its original rural state. I urge you to say no to this requested zoning change on Route 213 south of Chesapeake City. Back in 1960, there was a motion to construct a Firestone and a nuclear power plant on the north side of the C&D Canal. There was a large local outcry against the proposed plan, which would have changed the character of southern Cecil County forever. The result of this movement was to establish, preserve, and protect the rural legacy of the canal town south of the canal. It is now designated a resource preservation district and subsequently considered an SAR, Southern Agricultural Residential. As a result of these efforts, and as you know, Route 213 south of the canal is only one of 3 roads in Cecil County designated a scenic byway. These were all put in place to reinforce the rural character and to preserve the area. The ghosts of Northern Dancer and Kelso, 2 of the greatest racehorses to ever live who graced this county, both resided within a mile or so of this property under review. It would be a mistake and a tragedy to dishonor all the people who have worked tirelessly to preserve this area for future generations. The drive over the C&D Canal is now considered the gateway to the Eastern Shore. The character of southern Cecil County reflects the foresight and spirit of the people who understood that we do not need another Route 40, 896, or Kirkwood Highway south of the canal. We must preserve the land zone rural farmland, utilize the many unused commercially zoned properties already in Chesapeake City and protect our rural legacy. I am against this proposal. Thank you.
State your full name and your address, and if you hold a position in an important organization down in the First District.
Hello, I am Paige Howard. I work at Mount Harmon Plantation. I'm the director of Friends of Mount Harmon. I think many of you have been to our wonderful historic plantation and nature preserve. We are an official site on the Chesapeake Country National Scenic Byway. And as many have already said, it begins at Chesapeake City and continues down 213 through Cecil County. It is really one of the great tourism draws that bring people to Cecil County. And I want to draw your attention to two significant words in the title of this scenic byway: Chesapeake and country. People come to Cecil County because of the Chesapeake. It's the gateway to the Chesapeake, to the eastern shore. And when you come down that beautiful scenic byway, people are coming to experience the historic water towns and sites like Mount Harmon. So I'm very much opposed to the rezoning and very much encourage you to vote against it to preserve the rural character and scenic byway and the rural character of the region. The other word that's in the scenic byway is country. If we have a domino effect that starts with a Dollar General and then spurs all sorts of commercial development along the scenic byway, it'll become a Route 40 or 896 corridor. So I heartily encourage you to vote against this rezoning request. Thank you so much.
Caroline? State your full name and address, please.
My name is Alaire Hummel, and I live in 633 Budds Landing Road, Warwick, Maryland, which is right near Cecilton, Maryland, where we just actually had a Dollar General go up about 6 miles down the road from where this is being proposed. I just wanted to say that preservation has made Cecil County what it is today, a quaint farming and water-oriented community. Both the state and county and community have worked very hard to preserve this character. To mention a few, I know I've been involved in many of them. There's the MOUth, the Maryland Agricultural Land Preservation, the Rural Legacy, the Scenic Byway. I know they've worked very hard to get that through. My family has worked very hard, and many people in this room, I know, have worked very hard. The Eastern Shore Land Conservancy is another one. The Cecil Land Trust, all these groups have worked very hard to make Cecil County what it is, and it is a very special place. So I can only say that I only hope that the Planning and Zoning Committee not grant this zoning change, which would open the doors to much larger chains, not suitable or in character with this beautiful rural area. Thank you.
Christina? Caroline? But Christina, come on up. State your full name and address, please.
Hi, my name is Christina Vosters. I live on Randelia Road in Chesapeake City, Maryland. I have been a resident of Southern Cecil County my entire life. I grew up on a farm outside of Chesapeake City. I am a rising senior at Penn State University and an economics major. I have valued the rural landscape in Southern Cecil County all my life. I enjoy bringing my friends to the area. They marvel at the lovely countryside and the quaint historic towns, and all consistently express how unique this area is in that it is not overrun with commercial entities. They find it really quite fascinating that an area has been able to sustain such a beautiful landscape. The historic farms, which are abundant, are windows into our heritage. These lands need to be preserved not only for my generation, but for future generations to come. Keep the development where it has been designated. Do not heedlessly rezone land to satisfy commercial greed. We have enough of this already, and look at the congestion and clutter it has created in other areas in Cecil County and beyond. We need to develop responsibly in areas already designated. By doing this, the value of our landscape will accrue, and we will be protecting a valuable asset. Based on what I have learned as an economics major, overdevelopment and oversaturation in the long run will lead to economic downturn. We do not need this in a small town of Chesapeake City. It would really be harmful. I would also like to say that I've been so fortunate to grow up in this area, and I would like my kids to be able to see the same thing and enjoy what I have. So for future generations, please consider this. I'm highly against it, and thank you.
State your name and address, please.
Caroline DuPont Cricket, 284 Great House Farm Lane, Chesapeake City, Maryland. I came to Cecil County in 1960, and I had the privilege of having a mother-in-law who many of you knew, Blair DuPont. She taught me the value of preservation, conservation, and she loved this land, Chesapeake City, 213, and in the 60s and 70s, she worked tirelessly for Mouth in preserving the farmland. I have a 500-acre farm, which I do hay, and we're very proud, and Maryland's very proud of this district, and I hope you are, as we are. And people in this room have worked hand in hand with Blair, with me, and with everybody to make this so beautiful. And I am against it for all the stated reasons that have gone before me. And I hope that you will look when you go home and see the beauty and the work that's gone into this. Thank you.
Unless there's anyone else that would like to speak, I would like to ask the hands of those that are in opposition to this. Anyone that's in opposition to the application, so everyone that's here in opposition to raise their hand. I would just point out to the board that there are 345 signatures of people you know, voters and taxpayers in the county who have signed that petition. The character of South Chesapeake City is family-owned businesses and family-owned properties. If you bring in a chain store, and again, it may be a McDonald's here, the genie's out of the bottle, and the scenic highway, it cannot be replaced and repaired, it's gone. So I would suggest that the board respectfully deny the rezoning.
Is there anyone else in the audience that would like to present additional testimony in favor or in opposition to this matter? Everyone has spoken. Everyone's had their piece. Okay. Does the staff have any recommendations or comments on this application?
Thank you, Mr. President. Both the staff of the Office of Planning and Zoning as well as the Planning Commission have recommended approval of this request based on a mistake in the 2011 comprehensive rezoning. Mr. Houston will have the findings of fact, but just for the record, it should be a few statements earlier should be corrected. The priority funding areas map is not approved by the state; it's done by the local legislative body. The one we have now was done by the former Board of County Commissioners, and parcel 390 is located within that priority funding area. Mr. Houston has the findings of fact.
The findings of fact for this application are as follows. The neighborhood is an area within a half-mile radius of the subject parcel. The area is bordered by agricultural land to the east, commercial property to the south and north, and Bohemia Manor High School to the west. There have been no changes in the area since the 2011 comprehensive rezoning. The population changes. The 2000 population of Cecil County was 85,951. The 2010 census, the population of Cecil County was 101,108, or a 20.5% increase. This property is located within Census Tract 302. In 2000, the population of that census tract was 5,232. In 2010, it was 5,240, or a 0.15% increase. Public sewer and water are currently not available to this parcel. The access to this parcel will be from Maryland Route 213. Future development will be subject to the Maryland State Highway Administration and site plan approval. The compatibility with existing and proposed development of the area, the proposal should be compatible with the existing and proposed development. This property is located in the medium density growth area of the comprehensive plan. Medium density growth areas form the growth areas around the smaller towns of Cecilton, Chesapeake City, and Rising Sun. Medium growth areas may contain commercial uses, mostly at moderate intensities, as neighborhood commercial centers serving everyday shopping and personal service needs. And this parcel is not located in any special district.
Okay, I have to ask the question again because I think I've heard conflicting testimony. Is this property subject to rezoning in the priority funding area or not?
It is, excuse me, it is located within the priority funding area.
Are there any questions of the staff regarding this rezoning application?
Were you aware of the application not being signed by the owner of the additional parcel?
Yes, we are aware of that, and it has been our practice over the years that applications can be amended at the planning commission level, and that's why the application was allowed to be amended at that level.
So the owner of the other parcel has signed the application?
The owner of the .08 sliver of land that they're proposing to add to it has not signed the application.
Are they required to sign the application?
Owners are supposed to sign the applications.
Do any of the other council members have any questions of the staff? Okay, Mr. Leopold, you have your last statement to make if you have any comments.
The only points that we would make is that the property is a commercial property. We're not changing the property other than the fact that it is going to be a different commercial property. The water and sewer usage of a Dollar General would be significantly less than a restaurant. We just think, based on what it has been and what it has been for 30 years, we think just an error has been made.
Speaking to the mic, please, so that we're...
I'm James Allen Myers, Chesapeake City here, representing my parents, who unfortunately neither one can do much right now. But they've been operating it 46 and a half years and have owned it since 1978/79.
Okay, do the council members have any questions of the applicant before we conclude the hearing? Okay, then we'll conclude the hearing, the rezoning case number 2013-01, and we will make a final decision on this matter at our next legislative session on Tuesday, June 18th. Even though the hearing is concluded, if you have additional comments to speak to the council members, you certainly are welcome to call or email or write to them to discuss this matter if you have any additional.
Excuse me, but because this is a public hearing, I would recommend against any unilateral communication with the board, that any communication in regard to facts concerning this application should be made here tonight. The problem with getting additional information later on is that those in attendance at this meeting tonight are not privy to what that communication is. So I would recommend against that.
All right.
If you have anything to say, you need to say it tonight.
Did someone have something more to say? Have you been sworn in?
Yes, sir.
Did you want to come up to the lectern and state your case?
Not a good speaker, so. My name is Jennifer Bachman. I live at 63 Forest Lane, Chesapeake City. My concern with having something commercial across from the school, I have a child that goes there. We already have kids going back and forth, getting whatever. If you add something else, it's gonna add more traffic. We have a 50-mile-an-hour zone without any real school zone as far as how fast you can go. I mean, it's 50 miles an hour there. You're gonna add so much congestion. You got kids going back and forth. And I just think it's, you know, for our town, our community, it's, take it down the road. It's in Cecilton, it's in Elton. We don't need one here. You know, it's more safety for the kids. Why do we have to have it across from the school?
Okay, thank you. I saw one other person, you already spoke, I'm sorry. Is there somebody in the back that wanted to say something? Then you're the last person, help yourself.
Okay, I'm gonna stand up here and speak for my mother-in-law, Helen Myers, who is not here tonight.
Can we get your name, please, ma'am? I'm sorry.
Barbara Myers. She is not here tonight because she's home taking care of her husband, Jack. This has been a business, and another business is gone in its place. Unfortunately, after 46 years of business, she has had to shut the doors. She has given her heart and her soul to this community. She has got up at 4:30 in the morning and run that restaurant. She has given more to everyone in that community as far as Bohemian Manor goes. She has supported anybody who has asked her for anything. She has given. She would have given you the shirt off her back. This woman has blood, sweat, and tears for this county. She is looking to sell her business because she can no longer she can no longer run it. She wants to be able to sell to another business so she can have things in her life so she can retire. She doesn't have a lot of time left. And we as a family are trying to give her what she has desired and what she has worked for all her life. So I'm just here to represent her and to say that, you know, we are asking for, the only thing we're asking for is another business to take its place. It's not a piece of farmland. It is a business sitting on a property. That we're asking for a little sliver of land to make it another business that can go there. There is a business next door to it, a gas station. That is not farmland. It's a business area. So we're just asking for a replacement for a business for a business. And that's all that she is trying to do. She's not trying to put something there that's, you know, shouldn't go there. Thank you.
Okay, the hearing on rezoning case number 20-1301 is hereby concluded. Would the council manager please call the next case?
File number 2013-02, applicant Carpenter Engineering LLC, Ronnie B. Carpenter, property location at 995 Turkey Point Road in Northeast. Property owner Eustace W. Maida, request to rezone 21.5 acres from low-density residential LDR to high-density residential RM.
That's fine.
Mr. President, I have just been made aware of the fact that there is a preliminary matter to be brought before the board, perhaps immediately after these witnesses are sworn in. I understand Mr. Poole has an issue he needs to raise preliminarily.
So we'll have the council manager swearing the applicant.
Do you solemnly declare and affirm, under penalties of perjury, that the evidence you are about to give in this matter now pending shall be the truth, the whole truth, and nothing but the truth?
I do. Okay.
Mr. McCool, I understand he has a preliminary matter he's asked put before the, board.
President Hyde, with all due respect, this piece of property adjoins a piece of property that is currently held in trust by Shady Beach Trust, and one of the trustees is Sarah Amy McDaniel Argudo, and her daughter is involved in litigation with you, and they respectfully ask that you recuse yourself.
I'd love to be recused, but I don't see how that matter has anything to do with this request.
I understand your ruling, we're just bringing it up to the record.
I guess, I'll take it under consideration. You have objections to me presiding over this matter?
I would submit that, to avoid the appearance of any impropriety, that it would be best if you step back, yes. But you have to make the call based on your position and certainly advice from your counsel.
It's in here, this.
Yes, yes. Clerk Campbell is our counsel, please.
We haven't voted.
Officially, that's correct.
And it intrigues me as to what the circumstances are for the case are. It's an issue that has been brought.
Can I consult with you in private?
Sure, yeah, good.
We're going to take a 3-minute recess. Okay.